Well, I'm very pleased to introduce Eugene Gill Wanger and Professor Marla Sandys, with Diane Russ Tierney, Professor Michael Radlett, Professor Scott Phillips, Professor Michael Meltzner, Professor Daniel Coble, Professor Catherine Grasso. Thank you for your support of the National Death Penalty Archive.
At the bottom line, race matters. That's the bottom line, that anyone who asks me, race matters in how we administer criminal justice in this system. In a more sophisticated way, race matters in the selection of juries overwhelmingly and consistently. We have studied jury selection, the exercise of prosecutorial discretion in selecting jury members, peremptory strikes, right? In states all over this country. We just, we'll do one, they don't even publish. Someone will say, will you analyze this for us and see if it matters? And it's stunning to me, the pervasive influence of race in jury selection in this country. And what's hopeful to me is what the state of Washington did in reforming jury selection, and now what the state of California have done. So they both have said, we recognize that these bases for excluding citizens from serving on juries are not helpful. They're racist, and we don't need them to select a fair jury. So they outlawed certain things like demeanor.
The clemency decision comes after the courts have concluded their review in almost every instance, because governors and parole boards don't want to make a decision needlessly. So if it is possible that the states will resolve this in the courts, they'll let the courts handle it. So the kinds of arguments that you are making are often non-legal arguments in the sense that they're not based on cases. Attorneys want to cite cases as reasons for clemency, but the kinds of grounds that decision makers have cited have been things like disparities in punishment. So someone is sentenced to death, but the more culpable individual in the crime, who either was the trigger man or the mastermind, got life imprisonment. So a disparity in the punishment that's imposed is one possible ground for it. In a recent case that I've been involved in, I made an argument to the Ohio Parole Board that we were applying the death penalty in a systemically racist fashion. Not that any one case was necessarily marred by an equal protection violation, but the fact that 57% of the men on death row are Black, when we have a 12% African-American population in Ohio, really suggests a systemic problem in implementing the death penalty.
It's kind of interesting that we're coming around full circle. There's no way in which the Supreme Court, which I think, quite as you say, has washed its hands of anything significant in this area, is going to abolish, although it might have been on the verge of it before the 2016 election with a slightly different Supreme Court. So instead, the move is back to the states and to the population, to the public. And what we found is that there are fewer cases where the death penalty is sought. There are fewer cases where juries decide on capital punishment as opposed to life or life without parole, or perhaps worried about the innocence movement. And there have been, I think, 7 legislatures which have abolished in this century. So the future of the death penalty is really in the hands of the public and the states.
The death penalty is just a microcosm of broader society. It's not special in a sense. It is a reflection of broader historical trends and problems that we've never fully addressed in the United States. And, as your listeners know, some victims seem to, quote, matter more than others. The death of a white woman, especially a high status white woman, tends to send the system into overdrive. The death penalty is really overdrive for the system. And one way that I've thought about this is a death penalty case is an enormous amount of work. It's not simply going to be settled with a plea bargain. It's going to be two trials, really, a penalty trial after the guilt trial. It's going to be years of work in the appellate system to defend that conviction and defend that death sentence. And whose life and death is worthy of that additional effort? And the research says it's the life of a white victim, especially a white woman, and especially a high status victim. So I think the answer to the question is, if we, many of us are very interested in the death penalty, we read about it, we study it, but really it's just one aspect of a much broader set of circumstances in society.
Innocence is part of a larger argument about the death penalty, and that is the death penalty reserved for the worst of the worst? When we think of innocence, we think of people who legally and factually did not commit the crime. And, obviously they're not the worst of the worst. But we've got all sorts of other examples of people being sent to their deaths who were not the worst of the worst by any measure. People who have developmental disabilities, people who have long histories of abuse. As we speak now, in December of 2020, there are, right now we've already had 8 federal executions in the United States, and we've got 5 more scheduled before President Trump leaves office. But one of those people is a woman named Lisa Montgomery, not at all innocent. And you read the crime, she kidnapped a woman, cut a baby out of her uterus. She killed the woman, cut the baby out of the uterus. When you read it, anybody with half a brain is going to get sick to their stomach. But then you look at Lisa Montgomery's background. She was first raped at age 4. Her mom had, I think, 7 husbands who continually raped her, and their friends raped her. I mean, it's just a history of abuse that is equally horrible to the murder that Lisa Montgomery committed. One of my students the other day asked me if Ms. Montgomery had ever apologized for her crime, and I don't know if she has, but I know that we've not apologized for tolerating that kind of abuse.
If you look historically at how the death penalty has been used, it has always been used to say quite clearly which lives are worth more than others. You have seen from the time of slavery all through Jim Crow, where the same crimes did not carry the same punishment, where whether you get the death penalty or not depends on who you are and who your victim is. And so that is why we see that the death penalty is used disproportionately when victims are white, and in particular that people of color are disproportionately sentenced to death. And so one of the reasons that I am optimistic about us ending the death penalty ultimately is because I see that our country is on this path to really, for the first time, reckon with sort of the unfinished business of frankly, the Civil War. And we actually don't have a choice. We're confronting right now a very clear discussion about whether we're going to be a country that embraces and tolerates an ideology of white nationalism and white supremacy, or whether we're going to be a country that is actually going to try this incredible experiment of being a diverse, representative democracy.
Coming at it as a social scientist, not somebody trained in the law, there is this question of whether individuals are qualified to serve on a death penalty case, or you could say, are they qualified to vote for a sentence of death? But that has, changed over time. But the whole idea behind death qualification is, can you serve on a death penalty case? And historically, the question really focused on, could you vote for a sentence of death, right? Did you have any, so I often think of it as the pre-Witherspoon. Do you have any conscientious or religious scruples against the death penalty? And if so, you were excluded. And, it's obviously changed over time to where now there is this novelty of, could you also vote for life, right? I mean, historically, it was just, could your prospective jurors vote for a sentence of death, recognizing the awesome responsibility that that would involve. But then there was a realization that, wait a second, that process may result in individuals who couldn't consider even voting for a sentence of life. And so under the ideal circumstance, again, going back to what the law necessarily thinks about, is you want individuals who could consider aggravators and mitigators, decide on a sentence of death or life.
They're all of the issues: the conviction of the innocent, the whether or not the death penalty deterred murder, the racial discrimination and the death penalty. A number. In fact, there are about a dozen strong arguments, and I have files on all of them and books and pamphlets on almost all of them, and they can find those books and pamphlets in the collection. They go back to the 19th century, a few to the 18th century, but mostly 19th century, and of course, early 20th century. And you can find the development of this right along. And you can find a great deal of the scientific material that was published in original form, like Ehrlich's papers, which purported to show, using econometric analysis, that the death penalty did deter, which created a tremendous stir when it came out. Well, I got all the original publications that have it, so that someone who wants to know the history of that and how we handled it in Michigan is, that's just one of the things they can find out by looking at the collections.